Hello, I just
How are you doing?
okay, and yourself?
Good. So we have two cases scheduled.
Yes, sir.
Okay, and we got Odell Holmes and Michael Aronson in the waiting room. I guess we'll start with Michael Aronson. His is Seth Cooney, correct?
Yes, sir. Correct.
Okay, I'm going to admit him.
Okay.
Here we go. Hi, Mr. Aronson. How are you doing?
I'm doing good, Judge. Nice to see you. Hello, Michael. Hello,
Hi,
everybody.
Michael.
So this is Seth Cooney,
Yes,
and I know we were waiting for, you were going to, I don't know, somebody's checking on something. I'm not really too sure what it was. Is it resolved or we didn't need to go forward?
so far as I know, we need to go forward. Michael, is there something I don't know, or?
No, I believe that's for Mr. Villanueva from the previous Jonathan
this is-
Villanueva. So
this is a different one.
on
Okay,
that
I'm
one,
sorry.
it was actually lifted. It was resolved. So I'm just waiting to get the notice of dismissal to send out to you all.
Okay, all right, thank you.
This is a different one. Okay.
Correct.
Okay. What do we have on Mr. Cooney?
All right. So with Mr. Cooney, the department has received notice that he was involved in an accident that resulted in at least $1,000 property damage, and as well as no insurance being provided. This occurred January 6th of 2020. And on the crash report, it was indicated that he was traveling behind the other affected party, which was Norma Ordonez, in which he hit Miss Ordonez from behind. They both pulled over, exchanged information, and he didn't have any insurance. So this is where we're at, and the state is asking for an affirmative finding in this case.
Okay. Mr. Aronson?
Okay, so Judge, a couple of things I want to mention. The first thing I want to mention is this is a case that was originally filed in a different JP court. I think it was filed in a JP that wasn't a lawyer. So I had asked, I think it was Judge Frietz, if she wouldn't mind transferring this to some court where there's a lawyer as JP, which would be only 2 of the 8 courts. So she was kind enough to send this to you. And the reason I asked her to send it is because it involves rules of evidence. As the court knows, the rules of evidence do apply in these hearings. So the sole issue that the court has to decide is whether or not the pleadings in the DPS petition are true or not. The DPS petition, obviously, the court knows is this document right here. And what the other thing that's admissible along with the petition is a petition, but this is admissible because it has a 904 stamp on it, which exempts it from the hearsay rule. So the state has to prove its case from the documents that are from the information contained in this thing, the driving record. And here's my position. The 2 or the 3 other documents that if the DPS wanted to do appropriately under the law would have to be such that they would be admissible in evidence. Well, the crash report, it's my position, it's not admissible, it's hearsay. So the court can't consider the information contained in the accident report with regard to, so they have to prove the fact of the accident and that there's a probability a judgment could or might be rendered against them. So the first thing that they're trying to prove is not contained. There's no information in here other than on the second page, there's a notation. It says that there was a crash and that he was involved in a crash. Obviously, the fact of a crash is no evidence that he was at fault to where there might be a judgment rendered against him. So with regard to the evidence before the court, the only evidence that the court may consider is this document right here, which, as I said, is admissible in evidence because it has a 904 or 903 stamp on it. Now, they want to prove at least $1,000 of damage was sustained. They're attempting to do that through hearsay. Again, it's a bill from farmers that's about 7 or 8 pages long. And then with regard to not the damages, but the negligence portion, they're trying to prove it through a document that's not admissible in court. Judge, here's my problem, just, to switch gears for a second. The DPS, I love the DPS. I think Mike's a great guy, but let me tell you, they get away with murder. And if they want to come in and revoke somebody's license indefinitely, which is forever until the judgment is paid, then they need to start doing things right. They have counsel here in El Paso, and they have the benefit of counsel in Austin, but it's not right for a court to allow them to sneak through things. And I know that Mike would never do this on purpose. He's given whatever it is that he's given for a hearing. But if they want to make these things admissible for you to consider, then they need to do it right. They need to slap a business records affidavit on it. They need to slap some sort of a stamp on it or something. So because they don't have that now, and look, and who's to say they can't come back 50 times? Unfortunately, the law doesn't, I don't believe the law allows for double jeopardy in hearings like this, but make them do it right. So I'd ask the court for a negative finding due to that. There's no admissible evidence before the court to allow the court to make an affirmative finding. That's all I have.
Okay, Mr. Lugo, any response in regard to the evidence?
I mean, that's what I've provided you the discovery matrix that we're instructed to submit to the court, as well as the attorneys or the respondents when they request discovery. And that's part of what we're supposed to submit, a copy of the Texas DOT crash report and the itemized damage report, as well as I did include a certification from the Texas Department of Transportation to indicate that this is a true certified copy. And I would say that there is evidence.
What is a certified copy?
The crash report.
You submitted what? I'm sorry?
Certification from the Texas Department of Transportation. It's a letter from Jim Hollis, director of the Crash Data and Analysis section.
I don't have that.
I don't have that either. I don't
Okay.
have the police report. I have an estimate and supplements. That's all I've got.
Okay. I did submit it to Juanita June 8th of this year.
Oh, is it?
By email.
Is it no? Is this something from the Texas Department of Public Safety? It's a subrogation department. No, this is from.
Is this the document that you're referring to, just an accident report?
No. Well, it's this one here. So there's a letter from
I haven't seen that.
Okay. I was sure I sent it to you as well. Let me see if I did.
And I can look at my email right now and have a quick look at it.
Yes, sir. I sent that to Liz on August 10th.
Okay. Well, she forwards me all this stuff. I judge you. I don't know what the court wants to do. I mean, I can look in the file that I have, which is likely what was, according to Michael, sent to me by my secretary. I haven't seen that. I mean, I'm pretty careful about what I copy, and I have the file here, and I don't believe it's in the file. But however the court wants to do this, I mean, I don't have it. Apparently, the court doesn't have it.
And I was going to say the only other thing I would add is just that in regards to evidence of a crash or who was at fault, I would say that the drivers did exchange information, and Mr. Cunu provided his information to driver 2, which was Norma Ordonez. So otherwise, if a crash had not occurred, then they wouldn't have exchanged information.
I don't think Mr. Aronson is doubting that there was a crash. It's just there's got to be some evidence of fault or negligence on Mr. Cooney's part to attribute the accident to him.
I would just also say that if her vehicle was struck by, from behind and the damage to his vehicle was in the front, that would show evidence.
Yeah.
He's probably right, Your Honor, but it doesn't matter. The hearing is limited to the strict rule that you have to make your determination from their pleadings. You know, Michael's probably right. He doesn't have any reason to fabricate. That is probably what happened, but it doesn't matter that it probably happened. We can't take his testimony, which is based on multiple hearsay, and use it as evidence for the court to include in its decision-making process. That's just not right.
I'm of the same opinion. I think the Department of Public Safety should be held to the same standards anybody else is. And as far as proof, I've often wondered, in administrative hearings, the evidence rules still apply, Mr. Aronson?
Yes, and I've had this argument, there's one justice of the peace, well, anyway, I've had this argument with her, and I thought that she finally agreed with me, and we had another hearing that came up, and she said, well, I never said the rules of evidence applied. And I'm thinking, oh no, this is like a nightmare, my worst nightmare. And I sent her some cases that support that proposition, which I'll be happy to send to you also. They're just little blurbs in cases, just saying that rules of evidence apply in administrative hearings.
Juanita, do we have that other document that Mr. Lugo is referring to?
I don't. I've never seen it.
No, Judge, I don't have it. And also in reviewing JP7's case where everything is scanned, they don't have it either on file.
No, it wasn't, sorry to jump in. It wasn't something that I had at the time for JP7, but I had sent it to you on that date that I mentioned.
I scan everything into the case when I receive it, and I don't.
Because it's titled file, there's 5 attachments on the email that I sent to you June 8th. Do you see?
Unless I missed it, but.
Can I forward it again to you just real quick?
Sure, go ahead.
Okay.
Just looking at the case. I see if
so it's still sending right now.
Are you sending it to me also?
Yes, sir, I can send it to you. Let me get that one.
And Michael, did you say you received that document that you're calling a certification after the fact? In other words, you didn't have it at the time you sent out the original packet, or you didn't receive it at the same time as the other documents?
Correct. This was something I received from TxDOT separately.
And I might have a problem with that also, Your Honor, depending on what it says.
Mr. Lugo, can you send it to another email too? It's,
Yes, sir.
It's JP, the letters JP1 and El Paso County written out at gmail.com. Just so I can put it on the screen for everybody to see.
Okay, yes, sir.
JP1 El Paso County at gmail.com.
Oh, I'll forward it to him, Mike.
Oh, you did?
Yes.
Oh, you got it? Okay.
And let me make, Michael, is that some sort of a certification for which document, the accident report?
The crash report, yes, sir.
Okay, then, even, I haven't seen it yet, Judge, you haven't either, but here's what my position would be. Even if the certification is a valid certification, it's still, then in that case, it would only act to make the accident report admissible, but not the damages that are set out in separate documents. So even though they might be able to produce evidence of fault, they still wouldn't be able to produce evidence of the amount of the damages that they have to prove. And I'm not sure, what exception this is to the hearsay rule. It looks official. I don't know which exception this letter would come under. And I think that they would have the burden of showing why it is not hearsay.
This document may or may not take it out of the hearsay, but I appreciate your argument that this still doesn't establish the damages. So there's one element that's missing, so I'm going to issue a negative finding.
Okay, thank you. Your Honor, can you send me a copy if you don't mind?
Yes.
Okay, thank you very much. Nice to see it. Nice to see everybody. Bye, Judge. Bye, Michael.
Thank you.
Bye.
Bye-bye.
Okay, I'm going to allow Odell Holmes. I'm sure he's on this. Marcus Bradley Green. Let's see.
Yes, sir.
No, Mr. Holmes. Can you unmute? There's a blue button. You're not. There's Mr. Holmes. I was going to say, you're not the Odell Holmes I was expecting.
Yeah, to see if I had missed you. How are you? Good to see you.
Good to see you. Judge, how are you doing?
We're doing great. We're doing great, Judge. Thank
Good.
God safe and still kicking.
Good, good. I'm glad to see it and glad to actually see you.
Good to see you, sir.
So this is on Marcus Bradley Green.
It is.
Okay, Mr. Lugo, what do we have on Mr. Green?
Yes, sir. So with Mr. Green, he has been found incapable by the medical advisory board for sustaining or maintaining his driver's license. And the state is, well, on May 5th, I've attached some crash reports. Mr. Green had a diabetic episode while he was driving, in which he went into a guardrail. After the crash, he continued driving. He was unaware of law enforcement behind him with their lights and sirens. Continued to drive some more. And while driving, he ended up on a blown tire or rim for several miles, in which he was involved in another crash, in which he hit a fence and then subsequently a tree. He was transported to the hospital with blood sugar and blood pressure issues with regards to his diabetes. Luckily, nobody was hurt. And luckily, Mr. Green wasn't hurt as well, more so than what he did sustain at that time. But because of this medical event, the Medical Advisory Board, which consists of a 3-panel of board-certified doctors within the Texas Department of State Health Services, have deemed him incapable of safely driving currently. They are saying that within a 6-month period, he can be reevaluated by having his case reopened. But at this time, the state is asking for an affirmative finding to revoke his license.
Okay. Mr. Holmes?
Judge, will you hear some testimony from my client as to this incident and his situation with diabetes?
Sure.
Or do you want me to just summarize and I don't want to cross-examine Mr. Lugo, but do you have that report from the Medical Advisory Board?
I don't have the actual report. I have a letter.
A letter, okay. Yeah, where they suggest that their findings, there was insufficient evidence of control of blood sugar. That's a letter that's not dated, but we have since received the first letter shortly after the accident was May 17th, 2021, asking my client to obtain a medical history from his physician, which he did. And today he brings me that same letter and it's dated October 5th, 2021. Just a few days ago, telling him to do the same thing. So I'm not sure what the basis of the medical advisory board's opinion is, saying there's insufficient evidence of control of blood sugar, because the medical history from his longtime attending physician for many years says in more than one place he hadn't been evaluated for this problem for 2 years because he hadn't had this problem. That I don't know. Do you have a copy, Judge, of that medical report?
No, I don't. Like I said, all I have is a letter signed by
Yeah,
Indra
okay.
Hernandez.
Mr. Lugo, can I ask Mr. Lugo, did you present that to the court as part of this hearing?
This is the document that I sent in to yourself and the court, or to your client and the court.
Okay.
This-
Do you
This is from the
have,
medical advisory board. And
Oh.
well, if I may just real quick, this determination was made August 13th of this year.
August 13th?
Yes,
Where
sir.
does that date? Where
The
is the
first
date on it?
In the first paragraph.
Yes, sir.
Okay, all right. But they asked him to do that MAP report. Have you seen the MAP medical report that says that his diabetes is under control and has been under control, and he's never had the kind of episode that he had this time? This was the first and only. And this accident occurred, and I'm telling this, Judge, to you too. This accident occurred on May 5th, and they told him what to do to get a hearing, to get the medical report from his doctor, which he did, which gave him a clean bill of health except for this incident. And I'll read it. Her conclusion.
Mr. Holmes, just 1 second.
Yes,
When you're referring to a map, what are you referring to? Another map?
it's called, yeah, Judge, yeah. So I'm surprised that the state of Texas hadn't presented the evidence that contradicts their own medical advisory's report. It's on the Texas Health and Human Services stationery. MAP is the Medical Advisory Board Medical History Form. And they require you to complete this. It says below that, to be completed and returned by a licensed healthcare provider. So he
Right.
has to go to his doctor and get that report.
Right, and then
But
that
it's-
doctor sent it directly to the Texas Health and Human Services for their consideration.
Well, and it got sent to us when Mr. Lugo graciously indicated that my client could come by his office. He lives in Wichita Falls, but he's here because he's taking care of his mother, who has a lot of health issues. And my client went and got it, and Mr. Lugo gave him this MAP report, medical report, and that's the first time I've seen it. But let me, Judge, if I may, and I'll be happy to furnish the court a copy of this. Like I say, I'm surprised that Mr. Lugo didn't present that to the court. But if you need to see the physical report, I'll be happy to get it to you and ask you to consider it before you make a judgment in this case.
Okay,
So-
just so I know, just so I understand what we're looking at. What this is a report that his physician filled out, correct?
Right,
Okay,
his medical history.
okay, but and Mr. Lugo may be able to shed some light on, and then those are presented back to the board, and they consider that as part of their evidence, correct?
Correct. Yes, sir.
Okay, so my question is, was this ever sent back to the medical advisory board for their consideration by his doctor? Or did they not receive it?
Well, Mr. Lugo gave it to him. I presume it got sent back because it was part of the records, as I understood. Mr. Lugo furnished to my client is that
Right.
correct?
Yeah,
Yeah,
no,
well,
he gives it to the person and they take it to their doctor. The doctor fills it all out, and the doctor, not your client, but the doctor sends it directly to the board. It can't be your client. So it has to go directly from his doctor to the board.
Okay.
And if
And
I
that's
could ask
what
some
happened.
clarification,
Huh?
if I
And
could ask.
that's what happened.
Mr. Liberal, go ahead.
Yes, sir. All I provided to Mr. Green was a copy of his driver record, a copy of the MAB certification indicating the incapable finding, as well as the petition. I did not have any paperwork from his doctor, but it's, as you mentioned, that goes direct from his physician to the Department of State Health Services. And that's where they take into consideration. And based on their consideration and findings, August 13th of this year, they did find him incapable, and they said that they would like to have 6-month period documented without any other incidents before they'll review the case again.
Let me, Judge,
Safety.
my client would like to address that contention as to where this map form came from.
Okay.
When I went and picked up the forms from your office the other day, it had the reports that the police wrote. It had my doctor's, what she put. It had her letter that she put saying that if you have any questions about my history of diabetes, to call her. But you gave me that. That was in the packet you gave me.
Aside from that, all I provided was a crash report as well, but I did not provide any documentation or forms that you would take to your doctor.
No,
Not to take to the doctor that she already filled out.
and that you had possession of, because that's where he got them, Mr. Lugo.
I didn't have any
Did you ever
paperwork from his
see
doctor.
that? Huh?
I didn't have any paperwork aside from his, like, the crash report, the certification from the medical advisory board, his driving record. I didn't have any paperwork from his doctor.
Well, he picked up, you're familiar with these map forms, right?
Can you show it to me on the screen so I can
Yeah,
see?
I
what you're
don't know
talking
that
about?
I can. Hold on.
He gave me my doctor. I did go pick this up at my doctor's when I went.
Okay.
So I did not
She
see
filled
that
out-
form.
No, you didn't. You did not. I'm sorry. I just stapled it all to him when I got it and brought it to him. But she gave me the report that she filled out and
Okay.
sent to the medical report.
Okay.
I'm
When
sorry.
did she send it?
Right,
When did
sent
she
it back
send
in
it?
May or June. She sent it in June.
Okay. Well, I don't, these determinations are made by these medical experts. And I really don't get into an argument about, I'm not a doctor, so I don't really look at the medical reports myself. I allow that to be looked at by the professionals. But if it was sent back to the medical board, is that what it's called, Mr. Lugo?
Yes, sir, the medical advisory board.
If they're sent back to the medical advisory board, they consider those and then they consider other evidence and then they come up with their determination. My question is, did you get it back in time for them to consider that? Or did the doctor get back to them in time for them to consider that?
Well,
I mean, generally,
the letter, Judge, here's what I would like to do, Judge, if we can do. I was on the impression that this was in fact picked up by a client. He's corrected that. But the letter that is from a Dr. Mai, I guess, was dated August 30th, 2021. And so if I may I'm going to just go through some very quick highlights because the state says they didn't have they had insufficient evidence. How do they use that? They say in their letter, insufficient evidence of control of blood sugar. So in her report, she says the date of the exam, she says in her report, it asks about diabetic control and it says, yes, checks for that. It notes the date of the accident as being a hypoglycemic incident. And then she summarizes, and there's more to this, but she summarizes in her letter, if I may read, and I will present this to the court as evidence. And it says from Dr. Mai, Mr. Green is under my care for diabetes mellitus. His diabetes mellitus is under control. his hemoglobin AC1 has been running from 7.2 to 7.6, which my client advises me is within the normal range. He has been checking his home blood sugar. He has had infrequent low blood sugar. He has no record of hospitalization in the past 2 years due to low blood sugar. His diabetes mellitus is stable for him to drive care, she says. And then if you have any questions. In her summary on the MAP report, Judge, she says he is, this asks additional information. Please provide any additional information or specific comments regarding the patient's medical evaluation. He is under my care for diabetes mellitus since 2015. He has been on insulin, multiple daily injections. He has been testing home blood sugar. He has infrequent hypoglycemia. His diabetes has been controlled in the 7.2, 7.6 record. No record of hospitalization in the past 2 years due to diabetes mellitus. If my client was testifying, Judge, this is the only incident during his entire history of having diabetes that he has ever had an incident involving low blood sugar. He has that very infrequently. His problem is more with his blood sugar going too high. He's never had an accident of this nature. The DPS's history of his driving record shows that. And since this incident, he's been driving to this day, and he has never had another incident of it. And he's a caregiver for his mother. He's here in El Paso, and he needs to drive. He needs to drive to get her to her doctor appointments and caring for her in the store and other things. And since he lives in Wichita, he also is going to have surgery of his back and his neck. He's got a severe problem with that in November. So, and I think the other thing when he talked to somebody at the DPS about all of this, they basically, and Mr. Lugo referred to it generally, even though Mr. Lugo wasn't the source of this, that they just wanted to monitor him for 6 more months and see how he does, and not revoke his license, but to monitor his condition, which we were more than happy to accommodate based on what they direct.
But what the medical advisory board directs is 6 months before he is reconsidered or reevaluated to be eligible as a safe driver. Now, you indicated that this was only one time that this occurred. Now, it was a pretty big incident, though, that this occurred. And again, as I mentioned, thankful that nobody else was hurt or that Mr. Green himself wasn't hurt, but it could have easily gone down south a lot further. He could have hit somebody head on or somebody crossing the street. He was not aware of what was going on at that time. He was oblivious to law enforcement behind him for miles, several miles.
Well, that's not unusual, Mr. Lugo. When you have a hypoglycemic incident, that's exactly what it causes. So
Right,
that's not blameworthy. But the fact that he hasn't had a history of that, Judge, nor has he done it in the last 6 months, and the only incident is the accident, it doesn't seem to me there's a probability that that's going to continue to occur. It doesn't show up in his record before the incident, nor after it for 6 months from May until now. So there is plenty of evidence that he has a controlled blood sugar situation contrary to the statement that there was insufficient evidence of control of blood sugar.
Okay, let me ask a few questions just to get this term on.
Sure, absolutely. You
What
want to
I
ask
have-
them of my client?
No. What I have on the screen here is Flower Mae. That's the doctor that you just were reading the report of, correct?
Yes.
Yeah, I think that's the letter from the DPS.
Flower Mai is my doctor.
Oh, I'm sorry. Yeah, that's the letter from information provided by Dr. Mai.
Okay, so this is a letter from the Medical Advisory Board. And so they had this hearing, I guess, on August 13th, right? Didn't we establish August 13th? Mr. Green's doctor provided information. This is the information provided by the Texas Department of Public Safety and Flower Mae. So her information was considered, or his or her information was considered. What you're reading to me now is a letter or a second, I guess, examination on August 30th, correct?
No, that's just a letter from hers stating if y'all had any questions, or if the advisory board or you had any questions.
The letter that
For
Mr.
her.
Holmes was just reading, or the report was just reading, that was August 30th, was it not?
The report that he was reading off of is the one that she did for the medical review board. Only the top letter here in our possession is dated the 30th, because that's when I picked up all this information from her. And she wrote this letter on my behalf just to see if it would help me, because I didn't know what I was going to need for this hearing. So she wrote that for me.
Okay, so everything that she provided to the Medical Advisory Board is what you got, and an additional letter dated August 30th.
Yes, sir.
Okay. Well, again, I'm not going to second guess these doctors. I'm not going to, if they considered whatever your doctor provided, which apparently they did, because it's indicated on this letter that was considered, and they still came to that conclusion. And their assessment is that they need a 6-month period with no diabetic incident. And I'll ask you, Mr. Lugo, is that 6 months from the date of the accident or 6 months from the date of this order?
From the date of accident.
So we've already had that.
Well, we're there almost,
August, September,
aren't we, Mr. Lugo?
November. It would be November.
Not quite, but almost. But I would still ask for an affirmative finding, and then that way he has to have his case reopened at the time and go through the medical evaluation and board again, so they can observe and make their
I
determination.
mean, we're about 1 month or a month short of that 6-month period. So again, I'm not going to second guess these doctors. If they think that after the consideration of Mr. Green's doctor, whatever she provided, and they were still of the opinion that they need 6 months clear, I'm going to follow that.
Well, Judge, let me at least make this comment.
Okay.
That Dr. Mai's report, I'm not asking you to second guess the judgment of the medical board, because there is a conflict between what they have determined, even if they consider Dr. Mai's and what she says in her report, that this gentleman's diabetes has been controlled for years. This was an unfortunate singular incident of him, and it had to do with what he had eaten that morning, and took a shot of insulin, which lowers the blood sugar. So this was an unfortunate, unusual occurrence and one of a kind, Judge.
I'm sure Dr. Mai expressed that in her report to the board, did she not?
Well, she didn't express some of the facts I told you about how come he had this episode, but that's what
be for the doctors to
consider. But what she did say very clearly in her report, Judge, is that his blood sugar has been controlled. I'm quoting that from what she sent the board. Now, the board either did or didn't consider it, or if it did consider it, but your decision has to be based on the evidence introduced. That is what the medical advisory, how they interpreted the information they got, and how his treating physician considered it. And she's the one that's, they didn't examine him, they didn't see him, they just did it on the accident report, evidently, Judge.
No,
On
it
the
says right here
accident.
that the information provided by his doctor.
Well, but you know what? If they followed what the doctor sent to them and they did consider it, she tells them very clearly his blood sugar is controlled. I'll be happy to give, Judge, let me present this document to your court, either by email or something, and have you consider it before you make your decision. Because if they were considering all the evidence, and you consider this, you can consider this evidence outside of what the medical board's opinion is. That's because there's a conflict between what they decided and what she told them. He has a controlled blood sugar, and his driving record and history proves that. It proves he didn't have any incident like this before this. He's not had one 5-6 months later.
I'll be happy to look at what your report. Let me give you an email.
Okay, hold on, Judge. All right, give it to me.
It's JP, the letters J, lowercase JP1, El Paso County, written out, @gmail.com. But let me just say something. Here we have, I don't know, I'm not medically trained. I don't have any background in the health. So we have this condition that Mr. Green has, and I don't know how serious it is or not, but we have 3 doctors sitting on this board, and they have what was presented by the doctor of Mr. Green. And I don't know what the likelihood of this is reoccurring. I don't know any of this, the technical, the likelihood of it, the medically likelihood of it, and so forth. But these doctors, I assume, would. And so those 3 doctors were not swayed by whatever Dr. Mai provided. And so without any background, I don't see how I'm going to be, feel that I am qualified to,
Judge,
just dismiss
yeah.
a doctor's opinion, 3 doctors' opinions. But go ahead.
Well, Judge, let me just comment on that, because you're the fact finder. You're the fact finder in this as to what is the reality of the situation based on the presentation Mr. Lugo has made, and hopefully what we've made. And there's a divergence between the 3 doctors, I'm sure, and what his doctor has said. And so you're going to have to perform the traditional function of a judge or an administrative hearing officer as to whether or not there's sufficient evidence to prove that he has a condition that would enable them to revoke his license, when this is a one-time incident. And you as a fact finder can determine that his doctor knows his history better than anybody. And the question of whether his blood sugar is controlled or not is her opinion that it is controlled. And you could follow that opinion. You could follow what she says about it, contrary to what the 3 doctors said, without knowing anything about the medical background of it. It is 3 against 1 maybe, but 1's enough. If you take to heart what his doctor has said, coupled with the history that this is a one-time incident.
Okay, well, I will look at it and I will.
Okay, I know you will, Judge. I know you will.
So if you send it to that, let me just make sure I gave you the right email. 1 second, where is this?
And I'll read it back to you if that'll help. Yeah.
No, please.
Okay. All right, give it to me.
RT, and I'm sorry, I'm getting it's JP1 the letters, and then the number one, the numeral one, El Paso County @gmail.com.
At gmail.com.
Yes,
I
sir.
got it. I got it.
Okay.
I'll try to get this over to you today, and I would ask you to consider that document. I thought that that was a document that was part of what had been sent over to you, so I apologize for that misunderstanding. And once you have a chance to consider it, we appreciate your time and your consideration in this matter.
Thank you. Can you copy Mr. Lugo on it too on the email?
I will. Do I have your email, Mr. Lugo? What do I got up here? So
Are you ready?
let me see what I've got here. I found that letter. I've got, I don't have an email for you.
Okay. Yeah, just let me know when you're ready.
I'm ready.
All right, so it's Michael, Michael
Okay.
.Lugo, LUGO
Okay.
at DPS.
Say that
Texas.
again. Say
I'm
that
sorry?
again. EPS?
DPS,
No,
DPS. I'm
DPS.
sorry. I'm sorry.
Department of
Sorry.
Public Safety.
At DPS what?
.Texas spelled out TEXAS
Hmm.
.gov.
.gov.
Yes, sir.
Yeah. Okay. I'll send that over to you also.
All right, thank you.
Okay, thank you. Is that, you all have faxes that I could use, a fax by chance? Is that, Judge, you have a fax? or-
No, we don't have a
Okay,
fax. I'm sorry.
okay, email. All right, fair enough. I've
Thank
got
you,
them. We'll do
Thank you,
it, and then Judge, let us know. Judge, let me ask you this legally, and Mr. Lugo. If you're inclined in your decision to make that decision, I know this is a revocation proceeding, but as I read some of the statutes that I've reviewed, it was kind of confusing whether this was a revocation or a suspension. And I know you can probate a suspension. So can you, if this is a suspension process, can you probate it so that he can continue to drive pursuant to whatever those conditions would be of that suspension?
I don't believe I can suspend it. Mr. Lugo?
This is a revocation hearing, so no probationary period on this one is allowed.
So what you're telling me and the judge is, if the judge finds that there's grounds for revocation and revokes it, it'll be revoked for 1 month.
It would be revoked until the period that he had his case reopened and reheard by the medical advisory board.
I already seen
And
that.
how
He's
is that
already
done?
sent another letter?
Yes, and that's the one that stated before.
He would have to
Okay.
visit one of our offices and then ask that they reopen his case, so we get in contact with our Enforcement and Compliance Services division. They would reach out to MAB and reopen the case on their end.
In one of his local offices here in El Paso, DPS?
Correct.
When is the revocation effective?
The
At
11th day after the
judge's
date of the order.
Yeah, okay,
11th day after the date of the order. But Mr. Lugo,
okay.
are you sure that the 6-month period runs from the date of the accident?
Yes, sir. I can double check on that just to make sure.
Can I ask both of you all a question?
Sure.
The judge and you, I called the driver impairment at Texas, and I talked to the people about, they told me about the letter and the judgment of the 3 doctors that did that. He told me that I needed to initiate a medical review and ask for a new case for the medical advisory board. I did that, and I got a letter dated October the 5th today in the mail saying that I need to download the forms and start the process. To me, it's like starting it all over again, going to my doctor, getting her to evaluate my diabetes. It would be another 3 months of my blood sugars, because the last one she did was from like 3 or 4 months before, where she had my blood sugars, and this will be the new ones when I go in November, because I have an appointment in November. And but this is like, to me, this letter is just me starting it all over again, and I just got the letter today, dated
I mean,
October
if
the 5th.
If I could jump in real quick, that's what the process is. So when you have your case reopened, it's everything all over again because they need to start that reevaluation process. And so it's basically doing the same thing you did the first time over again.
Okay,
Well, so you'll know, Mr. Lugo, and I appreciate every time that I've tried to call you, you've called me back and we've missed each other. But
Yes,
when
sir.
I've tried to call you, your phone system says the system doesn't work and I can't reach you. If
You've left
you and I could
voicemail.
talk about maybe, huh?
You have left voicemail, so I
have.
don't know anything about the system being down. That's why I'm able to return your calls when I'm able to. The only thing is, this isn't my only role in DPS. In a leadership role, so I am doing some training with some new employees that we have outside. I do other aspects of the office as well, so I do try to call back when I'm able to, but I'm not always in my office.
You need to check your system because I'll tell you, I've called it a number of times and it says what is it saying?
says it's down.
It's down. The system's down.
Okay.
So your address, your phone number is 598-3487.
Extension
40225.
Yes,
That's
sir.
what I've been calling. So you might want to check that. But I don't know that I can talk to you. Have you seen this? So they sent him a letter October 5th. It looked like the letter they sent him May 5th or whenever it was. And now you say they want him to do the same thing over again.
Well, because it sounds like he already requested to have all that evaluation done to have the new case started. So that's what that
Okay.
process is.
And so how does that impact whether the court revokes or doesn't revoke? Obviously, they don't revoke. They can do it some more, or if he
It doesn't
revokes, he
impact
still
it at this
does it?
time. It
Pardon
doesn't
me?
impact it at this time because if they're going to reevaluate him, he has to have that new case reopened.
So can I use this one or I have to do it again?
You have to do it again from the date onwards. So you receive that letter October 5th, you
Yeah.
said?
It was dated. I received it today,
Okay,
but it was typed October the 5th.
yeah.
Okay. So yeah, everything should be dated after that because that's going to be for the new case. So they're going to be looking at new material.
Okay.
Okay, Judge, well, we'll get this over to you, Mr. Lugo. I'll send you a copy of the med map report. And Judge, we'll await your decision once I can get this stuff to you.
Okay, thank you. It's good to see you. Thank you.
Okay, Judge, thank you.
All right. Thank you.
Go. Thank you. I'm going to end the meeting. You take care too.
Take care. Bye.
Bye, Mr. Lugo.